I have, let's see, plaintiff's exhibits 1 through, looks like 21, and I have defendant's exhibits not marked in the way they should be, but there's a bunch of them. So have you had an opportunity, Ms. Larson, have you had an opportunity to review defendant's exhibits?
I have, yes.
Okay. And Ms. Ruff and Ms. McPhee, have you had an opportunity to review plaintiff's exhibits? Because you just got here. So they'll be put in front of you, and you can take a look at those. And I'm not sure which one of you is Sydney, but Sydney's the only party, so that she's the only one who gets to sit at council table.
Oh.
The parties get to sit at council table,
Sure.
Nobody else. So I'm going to take 3 minutes until it's 11 o'clock and give the defendants an opportunity to look at plaintiff's exhibits. And then I'll come back in. Go ahead and be seated. Do you remember paying a fee?
I did pay the fee.
Well, let's see what the staff says. Well, it shows that she filed an answer. No. It shows that Mackenzie McPhee filed an answer.
And only if they're married can they file together under the same fee.
Right. So the answer and counterclaim is only for Ms. McPhee, because she's the only one who filed a response. And so then, let me find my, so Ms. Ruff, you can sit in the back, and if you're a witness, Ms. McPhee can call you. Okay, so Ms. Larson and Ms. McPhee, please stand and raise your right hand. Do you solemnly swear that the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth? Mm-hmm. Okay, go ahead and be seated. And each of you bears the burden of proof on your claim. And so Ms. Larson has made a claim for $1,774.87. And so she bears the burden of proving that by a preponderance of the evidence. And Ms. McPhee, you've filed a counterclaim for $7,500, and you bear the burden of proof on that. So if we had a jury trial on this, I would instruct the jury that at the conclusion of the case, if they find the evidence evenly divided or equally divided, they must find against the person upon whom the burden of proof rests. So that means Ms. Larson has to prove her case by a preponderance of the evidence, and you have to prove your case by a preponderance of the evidence. And what you may find at the conclusion of the case is that I find the evidence evenly divided all the way across the board, and you both take nothing. Mm-hmm. And you may think that that's speculative, but I think I've done it at least 3 times in the last 2 weeks where nobody prevailed. So I just want you to be cognizant that that could happen. But Ms. Larson, you're the one who filed first. And so first I'm going to ask Ms. McPhee, do you have any objection to the court looking at plaintiff's exhibits 1 through 21?
No.
Okay, those will be received. And Ms. Larson, I don't know how to, I guess she's numbered these in a way that is not consistent with court process, but she's got circled numbers at the bottom, and the last number I see is 10. Do you have any objection to me looking at those?
No, I'd have no objections.
Okay, I'll receive those. Okay, so please state your full name and spell both first and last names.
Yeah, it's Sydney Celeste Larson, SYDNEYLARSON.
Okay. All right. What do you want to tell me with regard to this claim? And keep in mind that I have skimmed the exhibits. I never want to get too in depth because I'm not sure they're all going to come in, but kind of explain to me what formed the basis of your relationship with Ms. McPhee, and why do you think she owes you money?
Yeah, Your Honor, this is a case in which I have written up a contract with these two individuals that I worked with at my gaming company.
At what?
We have a video game entertainment company,
Okay.
and we wrote up a contract when they decided to leave, and it was for services and equipment that was received by them from us for a total of $1,774.87, and that was to be paid back to me by June 4th of this year.
Okay, so the contract that you're talking about is that
yeah,
your
Exhibit 1.
Exhibit 1, and then 2 has the itemization.
Yes.
Okay. And that was, okay. Now, did you have an employment contract or some other form of contract at the front end?
We do. We have contracts that I believe they actually put in their exhibits, but we didn't include that in this because this was just purely about the services and equipment upon leaving, and we had made a full new agreement for that, which is the Exhibit 1, and had the receipts handed to them that
So
day.
the contract that she's put in is, can you tell me which one it is?
Here, let me make sure.
Is it this?
I believe it says 3A
Okay.
on it. Those are non-disclosure agreements and video release forms and the contractor agreements.
So it's from June of 15? And any disagreement that these documents that are contained in 3 were the agreements between you and Ms. McPhee as part of their either independent contractor, I guess that's what they call it.
Yeah.
Is there any question by you that that's
I will
the
say
agreement?
that the agreement that I put in as my Exhibit 1 is what I'm here for because that is signed with me. However, the business ones are with my associate that is also here with me as a witness, but those contracts were not signed with me.
Okay, but those are from June of 15, correct?
Yeah.
Okay, and so, so that if I understand correctly, these exhibits could be both part of the defense that they don't owe you any money, and or it could also be to support their counterclaim that money is owed, maybe under those contracts. Would that be a reasonable assumption based on this?
Yeah, I will say that I was here for completely the new agreement. However, the counterclaim, I was not involved in the finances at that time, so I actually can't speak to those agreements or the financial back and forth between from those contracts from 2016. I was not in charge of the financials for us or them at that time.
But you see in her counterclaim that she's basing it on a contract that stipulated that she would receive 50% of her live streams while streaming in the employ of Girls Play.
Yes.
Okay, all right. So you can go ahead and proceed on your claim with regard to the 1,700 and change. Okay?
Yeah, thank you.
So you met with both Ms. McPhee and Ms. Ruff?
Yes,
And is that their signatures on this document?
yes, I met with them in person on
Your Exhibit 1 has something that's signed by 3 people.
yeah, that was the proposal that we put together and was finalized on the 7th of March. So March 7th, 2018.
Why is it that it's immediately above the signatures, it says terms amended 3/8/18?
because it was written before, and then we amended it. Oh, no. It says that it was amended?
That's what it says. Terms amended 3/8/2018 Mackenzie and Corey.
Oh, yes.
Terms amended 3/8/18
We
Sydney.
first discussed the...
Talk about this document.
Yes.
Is this your signature?
Yes.
And is Ms. Ruff's signature on it?
Yes.
And is Ms. McPhee's signature on it?
Yes.
And was this signed March 8th, 2018?
Yes, it was.
Okay. And,
Oh, no, I'm sorry. It was signed the 11th. I apologize.
okay. Is it your opinion that this document was to satisfy all of the, let's say, termination of your relationship with them?
Yes.
All financial?
Mm-hmm.
Okay. Okay. And at the time, and it says, I think somewhere in here it says something about attached, but the 1774-87, was that attached to this agreement?
It was handed to them that day that this agreement was signed on the 11th. All receipts were handed or had previously been emailed to them.
And the 1774, you've got a 163610.
Mm-hmm.
Does that 1774, is it 163610 plus 290 plus 2075 plus 13048, or is it some other amount?
So the first two amounts there were what us owed back to them for things they had
Okay.
purchased with us.
Okay.
And instead of paying that back straight, we said we could just take it away from the debt owed, which was the second two numbers associated with each of them.
Okay. And at the time that you met with them, did either of them dispute that these were money that they owed you and that they would pay it by June 4th, I think it was?
No, I was not aware of any
Okay.
disputes.
And between March 11th and June 4th, did they, I don't know if that's the right date, does it say it's by June 4th?
Yeah, that
Okay.
was the last day.
Between those two times, March 11th and June 4th, did either of them contact you and ask for an extension?
No, they did not.
Did either of them tender any monies to you?
No, they did not.
Did you have any contact with them during that time period at all?
I did, yes, through text message.
Okay, and so is that your Exhibit 3, or is that somewhere else?
Yes, that would be Exhibit 3 was when we were putting together the agreement, but the conversations during the actual after signing start at Exhibit 5.
Okay,
And that first Exhibit 5 was between me and both of them in that they stated that they wanted to start making payments, and I stated that the PayPal was our best way of doing that since we had previously done funds back and forth between that way. So
Okay.
that would be easiest.
okay. So Ms. McPhee is the one who said, hey guys, how should we start making payments on what we owe? And you said PayPal?
Yes.
So is that you writing to them?
Yes.
Okay. And so then it looks like May 16th, you wrote to them and said, hey, when are you going to start paying? And I guess it must be Ms. Ruff, because it says Corey, sorry we didn't respond sooner. And so at some point, was there a time where they said we're just not going to pay you, or what?
No, as far as I had known up until that May 16th, everything was still in agreement. As far as I knew, I just known there was no payments at all during that time. And that's why I had checked in, because I had about a week or two left on the agreement before it would be over, and I wanted to make sure that it got completed. So I heard back from them on May 30th, which you see on Exhibit 6. And they said they would email me. And then Exhibit 7 is the email that I got in return, in response,
Okay.
which was the first time that I had seen any sort of disagreement with the amounts owed.
So your company is called Girls Play?
Yes.
And what's theirs?
I believe at that time it was Stricodonia, but since then they are not in the same company anymore.
They're what?
They're not in the same
okay.
company anymore.
Okay. Anything further?
No, I
Okay.
think that's it.
All right. And Ms. McPhee, do you have questions of her?
I'm sorry, do I have questions of Sydney?
Uh-huh.
I do not.
Okay. And do you have any other witnesses?
I actually have two.
Okay.
I have Alex with me,
Okay.
who most of this was
Okay,
with.
come on up and raise your right hand. Do you solemnly swear that the testimony you're about to give in the cause now and hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead and be seated. Okay, what do you want him to do? Ask him questions.
Were you there for ordering of the parts and the equipment that we gave to both of these girls?
Yes.
Did they both agree to repay the value of at least the computer that we had built?
Yes.
For how many months did you deduct from Corey's paycheck to pay for the computer?
4 months, October, November, December, and January.
Of what year?
October, November, December of 2017, and January of 2018.
Why didn't we deduct that last payment for the computer in February of 2018?
At the time, Corey had already quit her other job and mentioned that the money she was making from this company was all that she was getting. And since it's supported primarily by tips and they were lower that month, we chose to not deduct from that month in particular because that way she would have more money available to her and we would just continue to carry the debt until it recovered.
Did you offer to repay the defendants for all the things if they returned all of the equipment that we were given to them?
Yes, the original plan was to repay what she had already paid for these things so that they would return the equipment. That's why the receipts, the first receipts they gave were my personal copies. They have a lot of sketch writing on it and totals. And so, yes, that was my plan, was to pay them back and then have the equipment returned. But they chose that they would rather pay it off, and we extended a 90-day term.
So you did help provide all receipts before they signed this
Yes.
agreement?
So I gave them my personal receipts, and then we gave them digital receipts later.
And that is all I have, Your Honor.
Okay, so I'm sorry. So at some point, your conversation with Ms. Ruff and Ms. McPhee was that if they brought back the computer and whatever else you had provided, that you would then give at least, I guess, Ms. Ruff, the $1,000 she'd already paid?
Yes, ma'am.
And call it good?
Yes.
Okay. And was there some other equipment that Ms. McPhee had?
Yes.
Okay.
So including the computer, we had set up with her a desk, peripheral equipment like mouse, keyboard, monitors, mounts, and then the company purchased a battery for her car at one point because she couldn't afford to pay for it at the time. And then there was a professional photo shoot that the company had paid for and was unable to use because they left the company about 2 weeks after. So since we couldn't use that, they offered to pay for that photo shoot.
And then they would keep
And then they would keep them. That's right.
photographs?
That's correct.
Okay. And so how much was that?
I believe the photography photo shoot was $400 and then hair and makeup was $190.
And is that contained on this
It is.
spreadsheet?
Yes, ma'am.
And at the time that this all occurred, were you and Ms. McPhee and Ms. Ruff all still friendly and getting along?
Yes.
Okay. And when did that fall apart?
I would say that Sydney and I have always attempted to be friendly, even to this point. The friction, I suppose, began when June 4th came and went, and the email that we received was no longer communicative. It was, here's my lawyer, go figure it out, which I believe is one of Sydney's exhibits.
Is not?
It is.
It is. The exhibit he is talking about, let me make sure I can find it.
I believe it's 12 or 13.
Yeah. Oh, yeah, 11.
Okay.
11 was the last one, so I had contacted them to check in again. I wanted to reach out, and it was June 14th at the time, and I had reached out on the 7th also and never heard back, so I decided to reach out again, and that last email is what I got in response, that we couldn't come to terms, and so we should speak to their lawyer.
I don't see the lawyer, I just see alternative pathways.
Oh.
What
Yes,
is that?
that's
Is that,
We assumed lawyer because the link was to a
lawyer
legal
site.
firm that
it
was on
was?
there.
I don't, oh, I see where it's allwaylaw.com.
Yeah.
Okay, all right. Anything further of this witness?
No.
Okay, do you have any questions of this witness?
I do.
Okay,
Alex, you claim to have not deducted money from Corey's last paycheck. Was there any point prior to her pay period that you informed her you'd be doing this?
yes.
Prior to Corey's last check, you informed her that you wouldn't be taking out $250 for her computer.
That's right. Yep. We had the conversation about her having not kept her job, and that this money was important. So I said, no worries. If necessary, we'll not deduct money out of your paycheck so you can have the money.
Thank you. That is all.
okay. Anything further?
No, I am good. Thank you so much.
So on the, okay. I won't have you address the issues at this time about the counterclaim.
Yes, ma'am.
Okay, go ahead and be seated. Anything further? Dealing right now just with what they say you owed. So go ahead and state your full name and spell your last name.
Mackenzie McPhee, last name MCF as in Frank, EE.
And spell your first name too, please.
MacKenzie.
Okay, so is this your signature on Exhibit 1?
It is.
And did you at that time agree with the 1774.87?
My name is specifically stipulated on the agreement for 2 different totals. How would you like me to discuss Corey's argument? We have separate totals due per person.
Okay. At the time you signed this, did you agree that the total that was owed was this 1774?
I agreed to sign for my total of $290 minus my receipts for $130. Corey, I remember, requested more information and asked if this total was for the remainder of her computer. And when she received a yes as an answer, she did sign.
Okay. And so at this point, based on this agreement, how much, so why didn't you pay the amount that you acknowledged you ordered between, or you acknowledged you owed between March 11th and June 4th?
The reason I was uncomfortable paying the $290 was because I did not receive the photos. The reason Corey was uncomfortable paying the $1,630.
You'll have to testify to
I'm
that.
so sorry.
Okay. So you still haven't received the photos?
I did receive the photos on June 1. I tendered June 2.
What did you tender?
I apologize that our exhibits are incorrectly labeled, but on 8, F and G, I stipulated for the photos.
So when you say you tendered it, did you actually give them a check or send it through PayPal?
No, I offered to pay.
So you offered to pay by the deadline that was June 4th, is that right?
No,
Wasn't June 4th the deadline?
it was.
Okay, so when was it that you offered to pay? You said you received the photos on June 1st.
I'm sorry, September 1st.
Oh, okay.
as per the text message from 8.
Okay. So between March 11th and June 4th, did you tell them that as soon as you received the photos, you would pay your $290?
In the email chain from packet 7, I stipulated multiple times that I had not yet received access to my photos.
And did you, during that time period, say, I will pay my $290 as soon as I get those photos?
I don't think I said it in so many words, but I did say I would like my photos before I'm paying for them. I also stated at the meeting for them to send me a bill.
What meeting?
The meeting we had on 3/7, the initial amendment of the terms, the initial meeting prior to amendment of the terms.
See, I can't see what the dates are on those, like on 3 or 7D, for example. I can't see what the date of that email is, and 7C, I can't see the date of that.
I believe those were attachments from the same date listed on 7A, Saturday, June 2. Attachments from that first email.
Okay. And what was their response to you about the...
They seem to think I have the photos, which I suppose could partly be accurate. I did receive a link to view them in a gallery, but the receipt that I received for photos stipulated that I should have digital access for high quality, high resolution downloads, and I could not acquire that through that link.
And how did you end up receiving the photos on September 1st?
We met for mediation, and I felt like after discussing with Sydney, maybe she didn't realize what part of the photos I hadn't acquired. So I called her on the phone and we discussed me receiving the photos and attempting to reconnect with the photographer to acquire the access, which is the text thread 8.
Okay. Okay. Anything else with regard to that?
Not for me, no.
Okay. And Ms. Larson, do you have questions of her with regard to her assertion with regard to the 290?
No, I will say that my Exhibit 20 was text messages from me to the photographer. The photographer is a friend of mine. And she had texted Corey, so she sent me a screenshot of messages with Corey with their link for their photos. So when I had checked in with Lindsay, the photographer, she had said that the girls did have their link and photos. So at that time, my complete knowledge was that they did have them, because terms they made with the photographer was that the photos would only go to them. So we never received them, and I've never even seen the photos myself. The photographer worked with them personally.
Okay.
So when she told me after mediation that she didn't have the link for the download portion of it, I contacted my friend again and got them in contact with her so that they could get their full photo shoot.
Okay. All right. And did you pay the $290 for the photos?
I did.
Okay. And so the what's your position with regard to whether or not Ms. McPhee owes Ms. Ruff's monies?
I had completely left that between the two of them. I wanted to make sure that we got paid back for the equipment, but at the time they were leaving, they left as a joint group, and they were starting another channel with the both of them on it that would have funds coming in for the both of them. So I had assumed that those funds would probably pay off both of theirs. But between them, if they wanted to pay only their portion, that was perfectly okay with me.
Okay. Do you have any questions of her with regard to what she just said?
Not with regards to what she just said, no.
Okay. And with regard to the defending their claim, do you have any witnesses?
I'd like to call Corey Ruff to the stand, please.
Okay, Ms. Ruff, come on up and raise your right hand. Do you solemnly swear that the testimony you're about to give in the cause now and hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please be seated, and once seated, please state your full name and spell your last name.
Corey Ruff, R-U-F-F,
And how do you spell your first name?
C-O-R-I.
Okay. All right, Ms. McPhee, you may inquire.
Corey, when you signed the agreement on 3/11, were you aware that the $1,636.10 was for anything additional besides the purchase of your computer?
I was not.
So you're saying you didn't have those receipts?
I did collect the receipts, yes.
Sorry?
Yes, I had the receipts.
Okay.
Corey, were you aware that your last paycheck was not going to be paying for your computer? Were you aware that the $250 that's been taken out of your check regularly every month was not going to be removed from that check that month?
I was not aware.
So was $250 withheld from your February check?
I believe so. It was continuously pulled every month.
Okay.
And there was no information otherwise.
Okay, so this testimony of Alex with regard to your conversation with him that you know, that money was tight, you're saying
That never
conversation
happened.
didn't occur? And do you have your final paycheck?
I do.
Receipt for it? Okay.
However, it is a handwritten check. But I do have it.
2C. Oh. As you can see, it's I'm sorry, I'm just gonna let you.
I'm sorry, which one?
2C.
Okay, so 2C is a check, 2C is dated December 31st, 17 for $2,000.
I'm so sorry.
2D is a check dated,
There are 3 checks in a row. One is dated 3/1. I apologize if they're out of order.
okay, one of them is January 30th for $22.50 it looks like. And 2E is March 1st and it's for $1,500.
That's my final paycheck.
Okay? Okay, any other questions of her?
Yes, Corey, when you, did your car break down while you were in the employment of GP?
Yes, the battery of my car did die.
Tell me what happened that day.
My car broke down in the studio parking lot. Alex Langford came. He dropped my car. He helped me at that time. A couple days later, he volunteered to give me a ride down to AutoZone, where we went down to AutoZone. We bought a car battery. At the time, I pulled out my debit card. He told me no, it's okay. I'd helped the company a lot, and that this was on him. And he offered to pay.
Were you aware at any time that you were going to be held accountable for the cost of that car battery?
I was not. And that car battery was 3 months, 3 full paychecks prior to my leaving.
So did you have Plaintiff's Exhibit 2 when you signed off on this agreement?
May I
Yes.
request to see the
This
document?
one that has the listing of,
Prior to signing?
Uh-huh.
No.
when did you get that?
I believe this came through sometime in June. I can't be positive of the date.
But the amount that's on there that says is owed by you, that is above your signature, indicates that that you owed them $1,636.10 with receipts provided.
That's correct.
Okay, which is the exact amount that is on this
That is
receipt.
not the document that I received. I don't know what exhibit number it is for Kenzie. This was the one that we received when we signed the documents.
4.
So you're saying that you owed $1636.10 for something other than what's listed on this,
Correct.
but you still didn't pay the $1636.10.
I did not.
Okay. Okay. other questions of this witness?
So you acknowledge you thought that $1,600 was the remainder of the computer parts only?
Yes.
Okay.
So this Exhibit 4, whose writing is this on here?
This is Alex Langford's writing. I believe the packet was already written on when I received it.
Okay. Because this is your packet of exhibits that I'm looking at.
Yes.
So you had this.
Yes.
Okay. Okay. Other questions of this witness?
Corey, at any point in time, were you made aware that Sydney was in charge of the company?
I'm sorry, that what?
That Sydney was in charge of the company?
There was many times that she stated she was in charge of the company.
Have you ever seen proof of that?
I have not. Every paycheck and everything has always been from Alex. The company's name is registered in Alex, and every paycheck is from Alex. And every receipt that was given to me was also from Alex.
Your Honor, am
Yes.
I allowed to request proof of ownership or proxy via Sydney and Alex?
From
So
this witness?
No, I'm
This
sorry.
witness is the one who's
Okay, I'm
testifying,
sorry.
so.
Corey, did you sign the agreement in good faith that it was specifically only for the computer?
I did. When we spoke, we had mentioned that number was exactly what I was willing to pay. However, the fact of that is that I asked for the receipts for my computer. I was handed the receipts to my computer. I thought it wasn't until later that I found out there was more being charged in that total. We had verbally discussed that these numbers, the financial numbers, were flexible and that those were not solid numbers when we signed.
As far as work expenses go, how often were you purchasing things that were work expenses, and how frequently were you reimbursed for those items?
Every month, whatever items that we purchased, we dropped off a receipt. At the end of the month, we would get a separate paycheck for reimbursement of whatever expense items we had.
You brought a photo of a bank statement for a charge for,
Is that one of your exhibits?
yes,
What number?
5E.
5 what?
E.
E, okay.
Looks like it says liquor store, 198 Salem, Oregon. Were you at any point told that you would be reimbursed for this item?
Yes, on multiple occasions.
Are you talking about at the Oregon liquor store?
Yes.
And 8545?
Correct.
Okay, so I'm sorry. You went to the liquor store, you bought something for 8545?
Yes.
And what was it?
It was mini bottles that we had used for a thing that we did on stream.
Okay. And what happened to those after your...
I bought them and I brought them to the studio, and everyone at the studio used them.
Their balls?
The mini bottles?
Bottles, okay. They used them, did they drink them?
Yes.
Okay. Okay.
Did you turn a receipt for this purchase?
I did.
Do you happen to remember around what time that was?
It was sitting in the folder upon my last paycheck. I had finally found the official receipt in the month of February.
But you've never received reimbursement for that item, nor is it stipulated on this expense sheet?
I have not. At the time that we had met to sign, when we were signing the document, Cindy agreed that there was multiple receipts that I had in my possession that were proof of purchase for GP expenses, and she said that I could turn them in and we would get it figured out.
And when did you find that receipt, for example?
I had that receipt in February.
Okay.
Or do you have any idea what this additional discount is listed on Plaintiff's Exhibit Number 2?
You have 10 minutes to put on your counterclaim.
Your Honor, I didn't know. I didn't know when to address this earlier, but I actually walked in here over a month ago and canceled my counterclaim. I amended my
Did?
claim. I did.
Let me look.
So I don't know where Corey's.
You just look. Okay. Oh, there it is. Okay. All right then. You have 10 minutes to finish your defense.
Okay. Sorry.
Can you get her some water?
Yeah.
Thank you.
I have no further questions for Corey.
Okay. Ms. Larson, do you have questions of her?
I actually do, Your Honor. Corey, you stated that the 1646 was what you understood as the remainder of your computer.
At time of signing, yes.
However, we had talked about the entire room of equipment and the photos that you agreed to also pay back, and we had said that those were in there. So I guess my question is, did you not understand that we had added the entire room and photo shoot to that amount that day when we handed it to you?
No, I never agreed to pay for the photo shoot. Mackenzie did.
Would that mean that then you wanted Mackenzie to pay for your half of the photo shoot that we had split down the middle?
No, there were two separate photo shoots purchased that day.
There was one photo shoot purchased that day.
It's not your turn to testify. It's your
Okay.
turn to ask a question. I see that there's $200 on one, above that says owed to GP from Corey, and one below that says photo shoot owed to GP from Mackenzie.
Mm-hmm.
Right?
I'm sorry, what, say that again?
Above the line, well, it says owed to GP from Corey, $200. And then owed to GP from Mackenzie, $200. Both of them say photo shoot. Right?
Can I see what you're looking at? First of all, I've never seen this exhibit before. How? But yes, on here I can see where it says there's a photo shoot.
And that both of them are dated February 21st.
Yes, that was the date of the photo shoot.
And so was it one photo shoot or more than one?
It was one session with two subjects. They had done a discount with their friend who said if they did two at a time that she would give them a discount.
And so the makeup was 90, photo shoot was 200, and it's listed on both you and Mackenzie's. And so was there a bill for, two different photo shoots that would total 290?
Yes, I believe so.
So 580 total? And, okay, go ahead.
So you put in for your exhibits number 4, and that whole collection, all of the Amazon receipts and the written agreement. Are you saying that you didn't get that before you signed the agreement with me?
I did receive that packet.
Okay, so you did have the receipts and the full number with full disclosure of everything that was included before we signed that agreement.
I had not looked through them, however, I had received them.
Okay, and you had them for 2 days before signing.
I did not. I didn't receive receipts until the 11th.
The packet that you guys put in as the 4th was handed to you on the first meeting, not when we signed the
Is that
agreement.
a question?
Sorry, yeah. So you're saying that I handed this to you the 11th when we signed.
Yes.
Did we not offer that you could return all of the things from the office and the computer, and we could nullify all debt owed, and that we would give you everything that we owed you, and we would also include that you could keep your hard drive to keep everything from the computer?
No, I was offered to return a computer to wipe the debt. There was no mention of any money offered back to me.
But you did want to keep all of the desk and chair and everything that was in the office when you left?
I did not. I was not offered that. I was only offered an option to return my computer itself without the hard drive.
So you're saying that we never offered to take back all of the stuff so that you could keep the computer and owe us less?
No. In fact, later I offered to return items I could not afford and was told they were not allowing returns.
Did you not tell us that after the agreement was actually over, though, instead of prior to the agreement actually
It
being
was
done?
during the terms. It was before the 4th.
Do you have that at all with you guys?
It's somewhere in the email chain, I believe.
But that was after June the 4th, right?
I would have to see the email chains, but I believe it was before the 4th.
I also wanted to ask that you didn't understand that the last paycheck didn't include your computer. However, didn't you know that our paychecks always changed month to month, so they were never the same, so there was no way of knowing if we actually left it in there or not?
Yes, that is true.
That's all, Your Honor.
Redirect of this witness.
Does that mean I can go sit down?
Print another one of these. Thank you. Do you have more questions of her?
Yeah, so, so when we instigated the email chain on June 2 to discuss our financial agreement, what receipts had you received at that time?
The receipts I had received at that time were the packet, and then we did receive the receipts for the photo shoot that Mackenzie was offering to pay for.
Did you at any time request this photo shoot?
Never.
So was this photo shoot a company requested expense?
Yes.
Did you at any point request to have a desk purchased for you?
No.
So was this desk a company purchased expense?
Yes.
And where is it now?
It is in my house.
You offered a summit mediation.
That's not
Oh, I'm
admissible.
sorry. I just meant to reference. What are you trying to pay for today?
Your Honor, I would like to offer to pay for the computer and what is owed on the computer and parts itself.
That is all. I don't have any questions.
And what, I don't know what that amount is.
The remaining total, I believe, is $666 and some change.
Is that part of your exhibit somewhere or not? So I don't know what the sum change would be.
I believe it's 64 cents.
I don't know why you'd want to have any number other than a 6. 666.66. Do you think you have it somewhere?
I think it's in her packet.
I believe it's in Exhibit 9 is where we put the remaining total. It's the single sheet.
It is 666.64. Anything further?
No, Your Honor.
Anything further?
No, I don't think so,
Okay.
Your Honor.
So just going to give you an opportunity, since you didn't file an answer. You want to talk to me about that?
I'm sorry, about what?
About the fact you didn't file an answer.
I thought I did. I'm sorry that I was not aware that I had messed that up.
Thank you.
I remember denying the claim, and then I processed $55.
So did you pay Ms. McPhee's fee, do you think? Did you pay Ms. McPhee's fee?
I'm sorry. Are you talking to me?
Yeah.
I don't think so. We weren't together when we filed it. Like, we were in the same room.
Okay. Yeah, we don't have any proof of an answer filed with your signature or a fee paid. At least, yeah. Okay. Okay. That's it. All right, Ms. Larson, any closing remarks?
Your Honor, I just hope that we could come to terms and that we could finish this with the original agreement, which was talked about and discussed and amended over a week, and no any denial or anything like that came until after the actual contract was completed.
And Ms. McPhee, anything further?
Yes, Your Honor. I merely wanted to address ownership of the company. At the time of my employment, the only person who owned the company was Alex Lane. I merely bring this up because I would like to prevent myself from being sued again in the future by a separate party. I would like to either receive proof or get acknowledgement that Sydney is acting in proxy or in privity with Alex Langford.
So, Ms. Larson, are you suing on behalf of the company as well as Mr.
No, this was completely the company and myself.
Okay.
At the time,
Does he have a separate cause of action against these folks?
no, he does not. At the time, I was taking the company over, and he was leaving the company. And I actually don't have it as an exhibit, but we did bring it today that I have put in that I am one of the people part of the company.
That you are what?
I'm not sure the exact wording of it, but I am part owner of the company.
Okay, so do you want to give that to her so? And who else is owner besides? Oh, I want to show
but I
that
have
to
this.
Ms. McPhee.
Yes. I don't have a copy with me, no.
We can make a copy if that,
I'd
if
appreciate
it
that.
helps you. So, Ms. Larson, are you saying that you cannot give Ms. McPhee assurances that she won't be sued by Mr. for some of the same stuff that you're here for?
No, I can't because I have only been in charge of the company recently. So anything prior to would be with him.
Okay, I do find that Ms. Ruff and Ms. McPhee do owe the company money. I'm finding that Ms. McPhee owes the $290, that she that there are costs and service expenses, that money judgment against her will be $390, and that Ms. Ruff, I'm going to, based on the evidence presented both in the case in chief and in the defense, that she owes the $666.64, that she owes costs and service expenses and prevailing party fee, and that the money judgment against her will be those things added together, $836.64. This I'm not sure how to do this, but it would seem to me that if Mr. was to seek anything that was contained within this litigation, it would be subject to claim preclusion because it was already brought, and it was part of this. I don't know if he thinks you owe him any other money, and I don't know if you think he owes you money. So that is for a different day, but at least everything that was in this litigation is resolved with these judgments. And it's under a legal theory that used to be called res judicata, but now is called claim preclusion. We'll do copies here. I need to put Ms. Ruff and Ms. McPhee's address in the judgment, so I'm going to ask you to make sure that we have that, and then we'll make copies of this for everybody. Do we hold on to these or we give them back? Thank you. These exhibits will be returned to you. And I wish all of you the best of luck.